Hi everyone, welcome to Impact Academy. So today let us continue with the Indian polity. So today let us look at the powers of Rajya Sabha. Okay, a money bill cannot be introduced in the Rajya Sabha. So we have already seen that only money bill can be introduced in the Lok Sabha. Also among the financial bills, there are two: financial bill one, financial bill two. In financial bill one also, if there are any what you say issues related to taxation, etc., then that also cannot be introduced in the Lok Sabha, Rajya Sabha. Okay, and both cases it requires the prior permission of the president. Other than the money bill, the ordinary bill and the financial bill too, etc., they don't need any prior permission of the president. So the Rajya Sabha has no power to reject or amend the money bill. So money bill, if it goes to the Rajya Sabha, it is just a matter of 14 days. Okay, nothing more. The Speaker of the Lok Sabha has sole and final power deciding whether a bill is a money bill. Though the Rajya Sabha can discuss it, it cannot vote for the public expenditure and demands for grants are not submitted for vote of the Rajya Sabha. Okay, so everything happens in the Lok Sabha. Okay, the Council of Ministers is responsible to the Lok Sabha and not to the Rajya Sabha. Okay, Article 75(3). Also, if there is a minister, okay, who is from the Rajya Sabha, he is also responsible to the Lok Sabha at the end. Even though he is from the Rajya Sabha, he can any minister can sit in the proceedings of the other house also, but he cannot vote. Okay, so Rajya Sabha suffers by reason of its numerical minority in case of a joint session to resolve a deadlock between the two houses. So as we have already seen, the president can call for a joint session if there is a deadlock between the two houses. It is passed by one house and it is not getting passed in the other house. So if the president wants, he can call for a joint sitting. But in case of joint sitting, as I have already told, there is a very high chance that the Lok Sabha will benefit because of the numerical majority. So Parliament can legislate on a state subject only if Rajya Sabha resolves for this by two-third majority, and the new All India services can be created only after Rajya Sabha resolves for this with a two-third majority. Okay, so this is very important because these are two cases where Rajya Sabha is actually more powerful than the Lok Sabha. Most of the times you can see that Lok Sabha is more powerful, but in cases like this, where Parliament can legislate on a state subject only if Rajya Sabha resolves for the purpose. So usually you have the state list, concurrent list, and union list, right? So the Parliament can legislate on a topic of the union list and the concurrent list. But when it comes to state list, it can only do so if a resolution by Rajya Sabha, okay, by that too passed by a two-third majority, not simple majority. Okay, and also any new all India services like IAS, IPS, if you want to create Indian Judicial Service or anything, or Indian Economic Service, okay, all these things. Indian Forest Service also was created only because of Rajya Sabha. Okay, so any new all India services can be created only if Rajya Sabha resolves for this with a two-third majority. So So when you're looking at position of Rajya Sabha, usually the constitutional position of the Rajya Sabha as compared with the Lok Sabha can be studied with three angles. That is where Rajya Sabha is equal to Lok Sabha, where Rajya Sabha is unequal to Lok Sabha, and where Rajya Sabha has special powers that are not there with the Lok Sabha. Okay. So if you look at it, equal status, okay, mostly ordinary bills. When it comes to ordinary bills, there is not much difference between Lok Sabha and Rajya Sabha. Passage of constitutional amendment bills. Constitutional amendment bills also there is equal status with Lok Sabha. Financial bill type 2. We've already discussed this, right? See, money bill and financial bill 1, where it involves taxation matters, it can be introduced only in the Lok Sabha. But if it is a financial bill type 2, it can be introduced both in Lok Sabha and Rajya Sabha. Financial bill type 2 means it contains financial issues and expenditure on the consolidated fund of India, but does not deal with those issues that have been defined in the Article 110. Okay, Article 110 deals with money bills. So mostly regarding taxation and all these things. So election and impeachment of the president. So we've already seen election of president. All the elected members of Lok Sabha, Rajya Sabha, all the elected members of Legislative Assembly and Union territories. When it comes to impeachment of president, states and union territories do not have any voting power. Only the all the members of the Lok Sabha and the Rajya Sabha, both nominated and directly elected members. Okay, so that's very important when it comes to president. Election and removal of vice president. RS can alone initiate removal. Okay, because vice president means he is the de facto chairman of the Rajya Sabha. So if you want to remove the speaker, his that removal of speaker resolution can be initiated only in the Lok Sabha. So similarly, for the vice president, who is the chairman of the Rajya Sabha, only Rajya Sabha can initiate the removal. So election and removal of vice president. Approval of ordinance issued by presidents. Okay, so when a president issues, when there is an ordinance that has been promulgated, because either Rajya Sabha or Lok Sabha is not in session, okay, then that approval can be done by both Lok Sabha and Rajya. Both Lok Sabha and Rajya Sabha are equal in that respect, and approval for emergencies also. So where they are not equal, they are mostly not equal when it comes to money bills. Money bills can be introduced only in Lok Sabha, that too with the prior permission of the president. Both money bill and financial bill one, where there is some issues related to taxation. Okay, that is where it becomes financial bill one, right? Financial bill one is basically money bill plus something else. Okay, it contains issues related to money bills plus some general matters also. Then it is called financial bill one. So if it contains only some financial matters other than those related to money bills, then that becomes financial bill 2. So financial bill 1 and money bill can be introduced only in Lok Sabha, that too with the prior permission of the president. Rajya Sabha has no power to amend or reject the money bill also. Okay, speaker presides over the joint sitting. So when there is a joint sitting, even though we have members from the Rajya Sabha, it is the speaker that presides. If the speaker is there, not there, then the deputy speaker. If the deputy speaker is not there, then it goes to the chairman and deputy chairman. Even if they are also not there, then some member, some MP appointed for that purpose. So Rajya Sabha can only discuss the budget regarding this demand for grants. Okay, it cannot vote on demand for grants. Remember that. Resolution for discontinuance of national emergency passed only by Lok Sabha. So once a national emergency is approved, for that approval, both Lok Sabha and Rajya Sabha are equal. Okay, both can approve. But for removing that emergency, for the resolution for discontinuation of the national emergency, it can be passed only by the Lok Sabha. And no confidence motion, removal of government can be only initiated in the Lok Sabha, because Rajya Sabha is a permanent body. Rajya Sabha cannot be dissolved. One third of the members retire every 2 years. That's all. Okay, Rajya Sabha is a permanent body, whereas Lok Sabha has no fixed term. If there is no confidence of the government, okay, the Lok Sabha can be removed completely. So, not no confidence motion can only be initiated in the Lok Sabha. So, special powers of Rajya Sabha. So, Rajya Sabha can authorize Parliament to make law on subject in the state list. So, only if the Rajya Sabha authorizes Parliament to make law on the subject in state list, only then the Parliament can make laws in state list. And that is Article 249. Try to remember. Rajya Sabha can authorize Parliament to create all India services. This is Article 312. Okay, this is also very important. And the special powers conferred to Rajya Sabha. Basically, in these two issues, Rajya Sabha has more powers than the Lok Sabha. Fine. So, let us quickly look at the parliamentary privileges also. So, parliamentary privileges are special rights, immunities, and exemptions enjoyed by the two houses of the parliament, their committees, and their members. So, parliamentary privileges also extend to the Attorney General of India. Remember this. So, the Attorney General also has parliamentary privileges. That means special rights, immunities, and some exemptions. Okay, and union ministers, but parliamentary privileges do not extend to the president, who is also integrated part of the parliament. So, this point is very important. Parliamentary privileges are basically to those who are in the parliament. Who is in the parliament? Lok Sabha, Rajya Sabha, and the president. Parliament is formed of three. Okay, president, Lok Sabha, and Rajya Sabha. Though president is part of the parliament, he is not a member of either Lok Sabha or Rajya Sabha. So the parliament privileges do not apply to the president, but they apply to the Attorney General of India, because Attorney General is also he can take part in the proceedings of the parliament. So originally, the Constitution, Article 105, expressly mentioned two privileges, that is freedom of speech, in Parliament and right of publication of its proceedings. So one is the freedom of speech and right of publication of its proceedings. So when we talk about collective privileges, it has the right to publish its reports, debates and proceedings, and also right to prohibit others from publishing the same. So regarding the debates and reports and everything, they have the right to publish and they can prohibit others to publish also. It can exclude strangers from its proceedings and hold secret sittings. Okay. So just because anyone wants, they cannot simply go and sit in the parliament. It can make rules to regulate its own procedure and the conduct of business and to adjudicate. Okay. It can punish members as well as outsiders for breach of privileges. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member. So if there is an MP, he cannot be arrested or convicted so easily. I mean, the parliament has the right to receive information about the arrest. The courts are prohibited to inquire into the proceedings of a house or its committees. Okay. So if the parliament appoints a committee, the courts cannot ask why. Okay, why are you appointing this committee? Okay, the courts cannot inquire into those things. Whatever happens in the parliament is according to the procedure of the parliament. Okay, courts cannot inquire into it. No person, either a member or outsider, can be arrested, and no legal process, civil or criminal, can be served within the presence of the house without the permission of the presiding officer. So this doesn't mean that he cannot be arrested. Just you cannot do it in the within the presence of the house. Okay, that too without the permission of the presiding officer. So we have other issues, right? So civil proceedings, you need to give 40 days before and 40 days after when a session or for that particular committee meeting is there. 40 days and before and 40 days after, you cannot arrest the person. Okay, that is in terms of civil proceedings only, not criminal proceedings. But even in criminal or civil, you cannot arrest or give notice within the presence of the house. Okay, so in order to maintain the sanctity of the parliament. So, okay, so that is about the collective privileges. So if you are looking at the individual privileges, the privileges belong to the members individually. They cannot be arrested during the session of the parliament and 40 days before the beginning of the session and 40 days after the end of a session. Okay, during the session of if a or that particular person is part of a committee and that committee is having a meeting, then 40 days before and 40 days after that particular session. And this is available only in case of civil cases and not in criminal cases. Okay, and that too criminal also you cannot do it within the presence. They have freedom of speech in parliament. That means no member is liable to any proceedings in any court for anything said or any vote given by him in parliament or its committees. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when a parliament is session. So when a parliament is going on, you cannot call a MP or someone to give evidence. Okay. So these are the collective privileges and the individual privileges which they have in the parliament. So breach of privilege and contempt of the house. When any individual or authority disregards or attacks any of the privileges, rights and immunities, either of the member individually or of the house in its collective capacity, the offence is termed as breach of privilege and is punishable by the house. For example, if any police officer goes and arrests this person, okay, member of the parliament in the presence of the parliament or in a civil case, if he arrests 40 days before and 40 days after, in such cases, action can be taken. Any act or omission which obstructs a house of parliament, its member or its officer in the performance of their functions is treated as contempt of the house. Okay. So if a MP is going to attend the parliament session and if you obstruct him on the way, that's also considered as a contempt of the house. So these are the collective privileges and individual privileges. Okay, the parliamentary privileges, and we have seen regarding the Rajya Sabha. Okay, where Rajya Sabha is equal, where Rajya Sabha is not equal, and all those things we have seen. So let us quickly look at the small part which is left here. Okay, we last in one session we have finished this one. So let us quickly look at this Consolidated Fund of India, Public Account of India. Okay, So budget in Parliament. The Constitution refers to the budget as the annual financial statement. In other words, the term budget has nowhere been used in the Constitution. Okay, so we have already seen Article 112, right? Article 112 is annual financial statement. 112. So the word budget has not been used in the Constitution anywhere. The railway budget was a separate from the general budget in 1924, but on the recommendations of the Ackworth Committee report. Okay, in 24 it was separate. In 2017, central government merged the railway budget into the general budget. Now there is no separate railway budget. It is the same. The president shall, in respect of every financial year, cause to be laid before both the houses of parliament a statement of estimated receipts and expenditure of the government of India for that year. So budget is nothing but a estimated receipt and expenditure. That's all. Okay. So over a period of time, budgets have gathered a lot of publicity, but budget is basically simple expenditure and receipt. That's all. So no demand for a grant shall be made except for the prior recommendation of the president. So in order to have any demand for grants, there needs to be a recommendation of the president. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Okay. So simply Consolidated Fund of India, you cannot what you say take money. It has to be through a proper law. And the controller and auditor general, the CAG, okay, is the authority which looks after all these fund, okay, how the fund is spent, etc. The expenditure charged on the Consolidated Fund of India shall not be submitted to the vote of Parliament. However, it can be discussed by the Parliament. Okay, only this demand for grants is voted upon, not the expenditure that is charged on the Consolidated Fund of India. For that, you don't need a separate vote. Okay, because it is going through this proper laws. The voting of demands for grants is the exclusive privilege of the Lok Sabha, that is, Rajya Sabha has no power. Okay, we've already seen, right? Rajya Sabha does not have power in this sense. The voting for demand for grants is only for exclusively for Lok Sabha. Parliament can also move motions to reduce any demand for grants. Such motions are called as cut motion. So, policy cut motion. It represents the disapproval of the policy underlying the demand. It states that the amount of the demand will be reduced to rupees 1. Okay, so if there is suppose the opposition or somewhere they do not agree with the so much amount being spent for a particular scheme or anything, then they can go for the cut motion. Economic cut motion, it states that the amount of the demand be reduced by a specified amount. Suppose they say we are giving 1,000 crores to this, it is reduced to 500 crores like that. Token cut, it ventilates a specific grievance that is within the sphere of responsibility of the government. It states that the amount will be reduced by 100. So the intention here is not to reduce the amount drastically, but just to show that a certain section of the parliament is not happy with it. Okay, so just to bring the issue out, okay, you have a token cut. So just for the sake of it, they reduce 100 rupees. If they want to completely reduce it, then they go for a policy cut motion. Policy cut means completely reduced to rupees 1. That means it, literally making it non-existent. So that is how inside within the parliament, the members show whether they are with the policy or not. So the constitution provides for the following three kinds of funds for the central government. So first is Consolidated Fund of India, which is Article 266. Okay, remember these articles also. Article 266, Consolidated Fund of India, fund to which all the receipts are credited and all payments are debited. All the legally authorized payments on behalf of the government of India are made out of this fund. Just like you, how if you're an individual, you have a bank account, you put money, you take money, right? Similarly, all these taxes, which everything they're collecting, all these penalties they're collecting, all the profits government business is making, everything goes to the Consolidated Fund of India. Okay, so all the receipts are credited and payments are debited. No money out of this fund can be appropriated, that is issued or drawn, except in accordance with the parliamentary law. So every year you have a budget. Okay, once the budget is voted, only then, that is with a proper law, you are able to use this money from the Consolidated Fund of India. So all this expenditure of the ministers, okay, payment of salaries, everything is taken from the Consolidated Fund of India. Okay, that is where all the money goes. That is where money is taken from. And one more is the public account of India. Again, this is Article 266. All other public money other than those which are credited to the Consolidated Fund of Money India received by or on behalf of the government of India shall be credited to the public account of India. So that which does not go to the consolidated fund goes to the public account. Example, it includes provident fund deposits, judicial deposits, saving bank deposits, So saving bank deposits and all, they are going to the public account of India. So departmental deposits, remittances, and so on. This account is operated by executive action. That is, the payments from this account can be made by without parliamentary appropriation. Appropriation. Okay. So provident fund, for example, we have provident fund regulatory authority and all these things, right? So, for example, if when a person wants to remove money from his provident fund, every time the parliament cannot go and make a law for it. So these things for which there is not requirement of any law, they are put in the public account. So one is the consolidated fund of India, and there is the public account of India. And the third one is the contingency fund of India. So first two are Article 266. The contingency fund of India is Article 267. The Parliament enacted the Contingency Fund of India Act in 1950. This fund is placed at the disposal of the President. Okay, and he can make advances out of it to meet unforeseen expenditure pending its authorization by the Parliament. Okay, so if there is any floods or any attack, okay, war or anything suddenly, so to use for emergency unforeseen expenditure, that is taken from the Contingency Fund of India 267. Okay, so it is three things: Consolidated Fund of India, Public Account of India, and Contingency Fund of India. So we have seen about powers of Rajya Sabha, okay, parliamentary privileges, and the various funds. Okay, that's all for today. Thank you.